Welcome to Civics in a Year, the podcast that makes civic literacy fast, accessible, and surprisingly engaging. In just 10 minutes an episode, we'll tackle one of 250 essential questions about American democracy, how it works, why it matters, and what it means for you. Whether you're a student, a teacher, or just someone who wants to better understand your country and your rights, you're in the right place. Civics in a Year is powered by the Civic Literacy Curriculum from the Center for American Civics and is produced in partnership with the School of Civic and Economic Thought and Leadership at Arizona State University. Welcome back to the Civics in a Year podcast. Today we are talking to Dr. Beinberg about the Fourth Amendment. Dr. Beinberg, what is the background of the Fourth Amendment?
It's basic. At its sort of earliest inspirations, it comes from English, the idea of English common law, protections against warrants and arbitrary searches. But in the United States context specifically, it's a reaction to a phenomenon that happened at the beginning of the sort of build up to the American Revolution, which is an idea called general warrants. Effectively, that the British government would authorize law enforcement in the colonists to just have sort of a freestanding warrant, whereas historically in England, you needed a more specific articulation of what you're looking for. And this became particularly problematic in New England and particularly Boston. And so, for example, in my memory is he was the Attorney General. I'm trying to remember exactly what the legal position was, but it was what it was titled. But functionally, the Attorney General of Massachusetts under the colonial government was a guy named James Otis, related to Mercy Otis Warren and Warren. It's a part of that sort of family. And I know that there's one we'll be doing on Mercy Otis Warren a little later. So they're part of a sort of family of revolutionaries. So Otis basically resigns in protest. He effectively says, like, I'm being asked to do things that are inconsistent with British traditions of civil liberties, that if we were in England, you wouldn't be able to just sort of take this waving warrants to go wherever you want, to search whatever you wanted. And so he resigned in protest, even though he'd been one, and gave up a very plum position. And a very young John Adams was very impressed by this. And this is part of why Otis became kind of a hero of his. Later on, Otis very quickly falls into poor health, so he sort of doesn't end up as one of the leaders of the revolution. But this causes a lot of the drafters of the various state constitutions to put in language that looks, in most cases, quite similar to the modern Fourth Amendment. Adams writes the Massachusetts Constitution, and his language is, I think, pretty close to the text of the current Fourth Amendment. But the Pennsylvania Constitution a few years earlier, which we've talked about and kind of knocked about, is one that the founders think is silly, but that's one that looks pretty similar to the modern Fourth Amendment. And so you can read through the text itself, but it basically tries to regularize the process of searches, right? Obviously, searches are legitimate, but they have to be, they have to have probable cause. You have to have, if you're securing a warrant, basically somebody attesting to it. You don't necessarily need a warrant for every search. This is something that people mistake. Okay. There is a strong presumption of a warrant, but it says unreasonable searches, right? Mm-hmm. So, for example, the courts have held that you don't necessarily need a warrant to search an automobile if you have probable cause, right? So if you see these people, basically, if you see people hanging out at a drug deal and then they're driving away, you don't need to go get a warrant because it's unreasonable. Mm-hmm. But you still need to be able to articulate, I saw these people talking to somebody who's a known drug dealer, handing a packet, handing money, right? So you need to be able to sort of articulate why you want to search this thing. That was a case from Prohibition, actually, rum running, whether you needed to do that. An opinion called Carroll versus United States that I think is one of Taft's best cases. But they're very adamant that they have to have sort of the probable cause parts. You can't just... So again, unreasonability is basically the metric. And you might say that's arbitrary, but there's tons and tons and tons of case law to build it out. So the core of the Fourth Amendment really is sort of a combination of honoring, again, traditional British civil liberties, and then being frustrated that those didn't seem to be extended in the colonial context. And so the various state constitutions had those in there to ensure that civil liberty was protected.
Can you, for our listeners, tell us what is a warrant?
Sure. Great question. So a warrant is effectively a document authorizing the police or whatever the relevant law enforcement is.
Mm-hmm.
Generally, it's going to be your local or state police. Could be the FBI or something like that if it's a more distinct thing. But to search premises, particularly a house, an office, something along those lines, searching for evidence of criminal wrongdoing. And so you might, for example, if a warrant is being issued against probable drug dealers, right, you're going to basically say, this is the facility that we want to search. Here's this address. We are looking for specific things. Again, you can't just say, we'd like to kick the doors in and look for whatever we want in a fishing expedition, right? You have to be able to articulate, we're looking for evidence of drug paraphernalia, or we're looking for this, or that. And you have to basically have a police officer attesting to that and some level of, or again, a law enforcement officer attesting, offering like why it is that they think this and articulating the probable cause, right? We were told by confidential informant number 5 that blah, 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 or something along those lines. So a warrant is effectively a way to guarantee that basically, or not, a guarantee overstates it, but a way to attempt to protect basically the authority of folks to maintain basically free liberty without a police state, but also still recognizing like we want law enforcement. And so a warrant is a way to basically regularize that process. And the particular features of it, like I said, you can look at the text of the Fourth Amendment, but it really is effectively, is this an arbitrary search? Or is there reason to believe that there's legitimate reason to do this? Again, probable cause doesn't necessarily mean 100% certainty, but it means we're reasonably confident about it based on evidence. It's not as high as the conviction standard, right? Beyond a reasonable doubt, but it's more than just like mere suspicion. Like, here's a piece of evidence about it, right? It's like, are we pretty sure that this is the case?
So now we kind of live in this world of technology that's moving very, very quickly. What does this look like in, with advances of all of this technology?
Right. So there's a couple of places. So the courts have wrestled with this in various ways. The core thing that I think is important to say is the court does not take the idea to simply say, like, a piece of technology that didn't exist then, therefore doesn't have Fourth Amendment implications, right? You see similar logic the way that they treat the Second Amendment, right? They don't just say it only applies to muskets. No, it applies to sort of weapons that are analogous. So similarly, the courts have held in a few cases. I think probably the most explicit articulation of this is a case about whether you needed a warrant to use thermal scanners inside a house. It's a 2001 case that Scalia wrote. And effectively, the question is this conceptually closer to a search of your house? And the majority of the Supreme Court said, just because these thermal scanners didn't exist in the 1780s, doesn't mean that we want to authorize this additional technology that functionally means now we're able to search your house. So in that case, and the court basically articulated and said, the same principles, the same logic, the same ideas behind this apply, even if it's being used to technological developments. And so they use, again, the same kind of methodology they use on the Second Amendment or on the First Amendment, right? It's not like, there wasn't an internet in 1780, so therefore there's no First Amendment. They said, no, like, these principles still basically hold. The logic of them still holds. So again, there are a couple places where this doctrine has gotten kind of a little complicated over the years. So one case is wiretapping in general. So in the 1920s, the Supreme Court basically said that wiretapping was not a search for this purpose, and so did not require a warrant. There were a couple dissents in that case, including some that effectively said, like, no, sort of the original logic of this is intruding in your house, particularly if it's a call that's in your house. It might be a little more different if you're like at a payphone or something, like a public payphone. It gets a little more complicated in that case. The court overturned that about 40 years later in a case called Katz versus United States. And they articulated so that there's almost two basic tests for the way that the court thinks about the Fourth Amendment. So one, something closer to the old standard. Is your property being trespassed on, right? Like, you didn't authorize a police officer to walk into your house, right? You need a warrant for them to be able to basically trespass functionally onto your property. So that old test still stands. But they added to it a concurrence from Justice Harlan, which are created as sort of a test called a reasonable suspicion of privacy, right? Basically, are you in a place where you have a reasonable suspicion of privacy? So in this case, you're on the telephone. You have a reason to not assume that the whole world is listening into a conversation that you and I might be having, even if I were in a payphone. I don't know for our younger listeners, a payphone, what's that? But my students laugh about that when we talk about this case. And so this creates sort of a parallel test. It doesn't replace the original test. And this came up again a few years later in an opinion called Jones versus United States, which is whether you needed a warrant to basically install a tracking device on a car. Obviously, if you're interfering with somebody's car, that would normally be kind of a trespass. And Justice Sotomayor, in what I think is probably her sort of strongest or best known opinion, or at least of her early years in the court, said, look, let's just make sure we have both of these tests. If it fails either the trespass test or the reasonable expectation of privacy, we'll invalidate the search. So the Fourth Amendment interpretation has been fairly robust, I would say, in terms of dealing with modern technology. There's one example that I would be negligent if I didn't talk about, which is sort of mass electronic surveillance. So not a telephone, but basically the internet. And this is where the original case from the 70s says effectively, do you have an expectation of privacy in who you talk to, right? So who you talk to. And originally, again, this is even before my time, you would get a record. I guess I saw a little bit of this early in my years, but you would get a record of who you called from the telephone company because you had to pay extra depending on if you were calling long distance, right? And so the court said, no one really assumes this is private in a way that like a private conversation is. You know that the phone company has this, and this is not sort of a secret. And so that created a case that said effectively who you call is not necessarily a secret. And that has been used in some cases to defend some of the mass surveillance stuff. That was initially, the lower courts and other people were sort of squabbling with this. A really terrific opinion by Judge Leon, so not a Supreme Court case, but a district court case, arguing, he said effectively, I don't think this case holds. The internet is so qualitatively different that we should treat this more like the regular wiretapping cases than the metadata who you're calling case. It ended up being sort of a moot discussion because Congress sort of stepped in and sort of tweaked the way that it was being dealt with. But that's the one case where I would say that the case law hasn't sort of stayed caught up in some ways. But otherwise, I always like reading these cases where the Supreme Court justices are saying, how do we best protect rights? Is it this test? Is it this test? You do see that on the Fourth Amendment in a way that you don't in a lot of other places where there's more sort of ideological overstates it, but methodological division. The Fourth Amendment cases more recently tend to be unanimous or pretty close to it, or two different opinions basically saying, let's use this test or let's use this test, but we're both going to side with the same, usually the individual often. So the Fourth Amendment is one where they have tried pretty hard to make sure that without changing the original meaning, without changing the original principles, but making sure that it applies, that it continues to be robustly applied.
Dr. Weinberg, thank you so much. I mean, I feel like when you read the Fourth Amendment, there's a lot in there, but you did a really good job at kind of distilling it down for our listeners. We appreciate it.
Thanks for joining us on another episode of Civics in a Year. If you enjoyed this episode, be sure to subscribe and share it with someone who cares about a constitutional republic as much as you do. For more episodes, resources, and updates, follow us on social media or visit us at civics.asu.edu. Make sure to check out the show notes for any relevant links. Special thanks to the United States Marine Band for their performance of the Stars and Stripes Forever. Let's keep building a stronger constitutional republic, one episode at a time.